We are continuing, and I want to ask Bojan Elek, the Deputy Director of the Belgrade Center for Security Policy, to join me here on the stage together with the panelists that he will present, and the topic will be digital rights and digital surveillance. Please, you come to the floor.
Good day, everyone. I would just like to ask all the panelists to join me. We will start right away because we have a very serious agenda. Our next panel will be about digital rights and digital surveillance. My name is Bojan Elek. I come from the Belgrade Center for Security Policies. I came from the analog world to the virtual one, but as we've said, they're all blended. But I just wanted to tell you why I'm here. For 2 years, I've been involved in discussions on multiple levels about the new law on the interior. You know that some sort of biometrical surveillance was suggested. We've all been informed about the great number of surveillance cameras installed in Belgrade and in other bigger cities. So who is watching us? This is the question that was asked. These cameras came from the Huawei company. So there were also questions raised about the identity of those who surveil us. There are also algorithms that process our data. Also, if I look back at these tragic events that occurred here 10 days ago, there are now persecution of people who write different sorts of things on social networks in order to allegedly improve our security. But the reverse of the medal is also endangerment of our freedom. So this is why we need to talk about the balance. We will be talking about all this with Toskić, Cvetinović from Partner Serbia, Bogdan, Banjac, Office of the Commissioner for Protection of Equality, Duško, Gudurić, Senior Advisor, Commissioner for Information of Public Importance and Personal Data Protection. So, Anna, please, we can be on the first name basis. If we talk about the digital surveillance, what is this? What rights are jeopardized? How can it influence the entire society? Thank you, Bojan. Is my mic on? Yes, good day. Thank you for the invitation. Bojan provided some context for us. I'm here because I wanted to talk about the topic that Bojan introduced. I would like to talk about the protection of human rights in the digital space and what is this digital surveillance. If we talk about the use of technology in order to ensure control over individuals, are these individual citizens, are they certain groups? Sometimes employers perform control over their employees. Why do we want to introduce biometric surveillance in our country? One of the traps is that we need surveillance in order to sort some social problems out, which was also mentioned during the previous panel. Is there social inequality? Is this discrimination? Is this the distribution of social allocation? Is this crime rate? Is this the protection against crime? Very often in narratives from the people in power. These are the narratives that can be heard, because in that way they want to resolve some social problems. But it's a trap, because if someone tells you, we really need this in order to find pedophiles or fight against organized crime, all those who say no will be potentially marked as those who wish to protect pedophiles and criminals. But the point is that during all the discussion with the Ministry of the Interior and the government is that if we want to solve social problems, the technology is not the only instrument that needs to be used. Technology has not caused these social problems. Technology did not cause the higher crime rates. Technology did not cause discrimination in our society and in other society. Technology can perhaps help us deal more easily with these problems. People were the ones who caused all these problems and not technologies. As Željka said, we have to start dealing with these issues and then start contemplating if technology is the culprit or perhaps a mechanism that can facilitate this task for us. If we talk about jeopardized rights, about endangered rights, I come from the organization that deal with personal data protection. Our privacy is always under attack. Our privacy is endangered because they are used for the creation of these systems. I have to admit that when we try to talk about citizens, about the dangers of these systems, it's way easier to talk about the dangers of discrimination, of social and economic rights, of the rights of special categories, LGBTI, all of them vulnerable groups. Then about our personal data, I will probably make a lot of digressions because you introduced the topic very well. We do not have an adequate law for personal data protection. It is perceived as something abstract. Breaches of the rights in virtual sphere have actually consequences in the real world if you do not have the right to social protection. If someone publishes the footages of you because you participated in a political gathering, if someone targets you because you use the application for meeting people, for meeting LGBTI people, this is actually the breach of your personal data. So these are the consequences of different sorts of discriminations.
Because this is interrelated and more visible than in any other context, speaking about this relationship between privacy and discrimination. Of course, freedom of assembly was also a concern, and the effects of living in a surveillance society, the chilling effect and the censorship in public space. And then, Duško, you're coming from the Office of Free Access to Information. So, what are the standards and what our law says on that? So good day. I'm coming from the sector of surveillance of personal protection data. This sector oversees the processing of personal data. This is not the right to personal data protection, but the right to lawful processing of such data. So these data are lawfully processed, and the Commissioner has recognized these issues, the lack of conscience of people when they give their personal data. So we started with the education of the youngest, meaning the children, students, etc. And in the digital caravan, we had discussions led in Bor, Priboj, and continues in Belgrade and other cities, where through education of this population, we tried to tell them what is the processing of personal data, to have the awareness as to what is personal data, when can we provide it. The feedback is that they understand, the kids, what is protection. They are hasty, and they desire to get to something is much greater than the knowledge. So we recognized it, and through our 1 hour or 2 hour activities that we have in this digital caravan, we are trying to raise the awareness of children and other people as about the processing of personal data. And we are continuing, meaning the Commissioner, going further. We have a GIZ project about protection of personal data, the training of authorities, also the strategy on personal data protection, the most important thing happening in Serbia, an umbrella document covering the period until 2030. And the Commissioner hopes by the end of the year that this strategy will be adopted, which will be the basis to have a law on personal data protection or the amendments thereto. And what other laws have failed to harmonize with this personal data protection law. Video surveillance, biometrics, other things that are not covered by this law, but other special laws, since the law on personal data protection is an umbrella law, and it gives certain guidelines, such as the GDPR.
An interesting question. What was the role of the Commissioner? Do you know something about that? Could you tell us something about that? There was some close consultation. I did work in the sector for harmonization, and the Ministry of the Interior did reach the Commissioner. I did not participate in the emission of that opinion, but this is the legal obligation emanating from the law when it comes to the assessment of the influence. The opinion of the Commissioner is required. If we talk about biometry, I think that you can see on the site of the Commissioner for Information of Public Importance, and I mentioned discrimination in the digital sphere. But could Bogdan tell us something more about that now? Yes, we can talk about different forms of discrimination that occurs in the digital sphere. What comes to our minds for the first glance is actually the hate speech as set forth in the law against discrimination. The Commissioner actually issued 63 opinions. Anna mentioned that it was really very hard not to mention the right to privacy. But if we talk about the surveillance equality is perhaps less important than the personal data protection. All this is the part of the wider context of the human rights. If we talk about vulnerable social groups, an important risk factor that might cause discrimination is exactly this. We did have examples of revelation of HIV positive status of patients, and we have some more blatant examples of that sort. I do agree with the statement that surveillance is something that is an inhibitor to equality of certain groups and of freedom of speech, because actually internet is the great equalizer, and actually thanks to it some groups were able to express themselves, and this is why we really need to be very cautious while gathering and surveilling personal data. We should assess what has been going on in the world so far. We had an example in Canada. I don't want to talk about concrete cases, but there was one company that had certain capacity of video surveillance that actually sold these data. The company does not exist in Canada anymore due to that. An AI software was used for face recognition, which caused the arrest of persons that were not responsible. And basically, artificial intelligence caused the arrest of persons who had not been responsible for certain acts. It was in Detroit. I don't even want to mention democratic processes in a country. The law against discrimination in Article 14 actually talks about the equality principles that needs to be taken into account, whichever measure needs to be implemented. Fundamental principles of human rights actually asks a few questions. Is something proportional? Is something regulated by the law? We need to assess in detail the impact on the entire society and on the principle of equality per se. Okay, the aim of this event is also to promote good practices and independent institutions that deal with this area. So what does the Commissioner for Protection of Equality can do if we talk about the protection against digital?
We have a campaign we are proud of. It's localizing a campaign which happens globally, implemented by the UNFPA, the Body Right campaign, actually. A global campaign started in November 2021. It started in Serbia, again in November, but in 22, under the name Your Body is Yours Online and in the Real World. The campaign has several segments. One, the most important one, is raising the awareness about the notion of digital violence, what it entails, and what are the mechanisms of protection from digital violence. We all know that, as well it has been already said in the discussion, the internet is just a tool, but if someone is malicious with poor intentions in every context, with every technology or platform, they will find a way to do harm to someone. Our task is, well, to inform the public, raise the awareness of sensible social groups, in view of the fact that women are 27 times more, apparently, there are several studies, of course, 27 times more exposed to digital violence. children too. So one of the most important tasks is to raise the awareness about that and about the mechanisms. As well, perhaps it's lodging a criminal complaint or going to the commissioner. And the mini segment in that campaign was like, confide yourself to the commissioner. So we have tried to come closer to a wide range of people that could use us in order to protect their rights. And I can say that there was a video that was well done. Constructa was our figurehead of the campaign. And also, we need to change the legislative framework. We had an initiative to change the penal code. We wanted to incriminate sharing and misusing sexually explicit content. This is one of the more dangerous types of digital violence that has consequences for victims. And one of our activities also, which is happening lately, is that we're trying to empower people to be educators, and in the workshops in Serbia, together with other young people, their peers, to bring closer the dangers and protection mechanisms. Also, in the global campaign, we have made a glossary of digital violence, which was translated in Serbian during the campaign. So this is yet another useful tool for those that have experienced digital violence. Thank you. So how is the Commissioner acting when there is misconduct or personal data?
These are the two things that the Commissioner does. It acts upon complaints, and if someone thinks that the rights have been breached, the Commissioner actually sees whether there are grounds emanating from the law on the personal data protection. The sector where I work deals with data, with personal data. If whoever reaches the Commissioner and files a complaint, the Commissioner ex officio initiates the procedure in order to determine whether the personal data were actually processed under illegal or unlawful circumstances. If the purpose of the data treatment did not emanate from the law, the Commissioner acts. I personally and my colleagues, we had a lot of complaints regarding surveillance, regarding personal data, hackers' attacks, when there were thousands of data compromised. You've heard certainly cases of locking the data in different companies, and there are the situations where different people use these processes. Biometry is cheap now. Our phones provide for biometry. Wherever you go, you can see a face recognition device. For instance, when you enter a company, at the very entrance, you have a biometrical face recognition device. My colleague attended a meeting in France or in Germany, biometry is a global problem. This is what was concluded. The problem has been recognized, but we do not know how to solve it. We actually swim in that same mud. We are trying to go to the surface. In the majority of the cases, we forbid biometry because actually it jeopardizes privacy. I was actually talking about the employer that had introduced biometry, but the treatment of the data of patterns must be done, must be duly done. A computer that unlocks the door needs to be in a separate place. The surveillance room needs to be locked. The key needs to be kept in the safe. So the employer needs to pay attention to all security details. Only one person can have the access to that computer. So you should always have one person in charge and one person who should be responsible of security. If we talk about the law on personal data protection, I would just like to add that employees should not use the proceedings to do the facial recognition. But despite of all that, the data can leak. So that basically means that these data can be revealed and therefore not sufficiently protected. Well, this is a public event. I don't know if these cameras that film us are sufficiently protected. We actually try to see where cameras could be installed if perhaps the entrance to a building had a camera. If we want to talk about security of citizens, we actually need to take into the account the balance between the privacy and the personal data protection and safety and security. We really need to consider all the facts before coming to a conclusion and before issuing the opinion. Thank you very much, Duško. You said that we are swimming in the same mud as everyone else, but are there any discussions in the EU? So could you please tell us something about European standard and about the latest AI draft in the EU?
Just shortly to say something about what Duško said. This is very important, that the Commissioner intervenes in situations where, for example, the processing of biometric data is not regulated by law, but it's contained in the Data Protection Act. And this is an important argument speaking to everybody, thinking that now, today, some new regulations will deal without problem. Until this regulation exists, nobody should do anything, or even worse, this is not regulated, so everybody can do it, because this is not true. So we have a law which is in harmony with GDPR, the called international standard. Well, someone may like it or not, but this is how it is. And this law prescribes some mandatory principles, meaning transparency, proportionality, anonymization, etc. So this is what we should be pointing to always. we are one of the first countries which are at the level of soft law. We started developing regulations and also international standards. Before that, UN, Council of Europe. They worked and still working on developing instructions, guidelines at the level of the rules when it comes to AI, etc. And in order to make this development and application be useful to people and to respect basic human rights. As you said, it's very important, meaning what is happening at the level of the EU, the long-standing work on of drafting the AI regulation, and a couple of days ago, the EP will vote. The good messages are the decisions about banning AI, including the biometric surveillance with automatic face recognition in public spaces, and also processing of biometric data for post-identification. If you remember, the processing of biometric data for the need of identifying people that have allegedly committed a crime. And now the position is that such processing is forbidden, but it could be allowed only for the processing of serious crime with the supervision of the court. And this is extremely important. Other activities are also mentioned as prohibited. The predictive policing, the use of AI for predicting possible repetition of crime based on prior behavior, based on someone's criminal record. Just like what GDPR work on the AI Act entailed attempts to reach a compromise between different interests. Yesterday, we discussed with our colleagues and those working in the EP, and we want to believe, actually, that now this latest position of the EP is partly adopted due to things that happened in Serbia, because it has become more clear, not the importance of regulating specific areas, but takes the context in consideration. When you have Serbia or EU member countries, which is in the crisis of democratic institutions or does not have powerful mechanisms to protect their rights, you see how this technology can be used, what are the dangers, before being able to see it in a country with well-functioning institutions. One of the arguments we are facing is like, okay, the UK uses face recognition systems, CCTVs all over France. This is true. We are not saying that these are good practices. But what is the difference compared to the most EU countries? We don't have any jurisprudence. Our courts and our prosecutors' offices are not trained enough. Our independent authorities do not have the capacities. Our citizens are not aware as to what are their rights for these mechanisms to be able to initiate it. Until this happens, we must be a country which is raising the bar much higher. It's great that at this level AI Act is adopted, but I think that our borders, our limits must be set much higher until we have the democratic infrastructure, when these mechanisms are really used, that we can have independent authorities that have sufficient capacities to address all cases, because these capacities are, of course, limited. Technical knowledge is, well, scarce. Similar cases with the commissioner, courts, of course, and prosecutors' offices. So I think that the role of the civil society, until these standards are set, are extremely important in overseeing these mechanisms, initiating dialogue, which, well, I agree, must be multi-sectoral. What we had in the process is of adopting the strategy, of developing AI, and then adoption and making the draft about the law on the internal affairs. It was not multi-stakeholder approach, because these are topics that have an impact on all the societies, and all stakeholders should be included. There are good experiences at the EU level, also in the reaction of their independent bodies that prohibited certain processing, the key view, different algorithms that are used in Greece for the control of migrants, asylum seekers, and also very important questions that we are yet to address. And this is the question of procurement of equipment. Because, for example, last year, the EU adopted a very important opinion about the donation of the EC to European countries which use these resources in order to buy surveillance equipment. And then the question was whether the one giving the money for the procurement of equipment must do a human rights impact assessment study, as it should happen in procurement, which are also in this area.
Thank you, Anna. We're entering the last set of questions. There are dangers everywhere. Regulators and legislators are trying to keep up the pace, and I hope that the Euro parliamentarians actually were against the introduction of it. So I will give each of you 2 minutes to tell us what can we do as citizens in the field of digital hygiene to protect ourselves. So please give us some practical advice. I'm a jurist, and it's clear that an absolute protection does not exist. I think, and my colleagues will probably say more about that, is not only the personal digital hygiene, but also the way in which we protect personal data of others. If you are aware of the importance of personal data protection and of the consequences, do you feel the same when you share personal data of your friends, when you use the application that can access your gallery, for instance? What is an evolutionary question if we talk about privacy rights is that actually it surpasses individuality, because whatever you do have an impact on your surroundings and on the community. We've been trying to talk about this, about the encryption, about profile protections. But as I've said, I'm a jurist, and I think that we need to use mechanisms that are available. We cannot wait for the new regulation. We have to wake up the prosecutor. We have to pressure the regulators because they have to know everything about profit generation, about leakage of data in the media, and this is something that needs to remain in the focus. We do not have a solution for these problems on the global level. We have to work on the education, but everything has to go hand in hand. Yes, so Duško, how can people protect their own data. Yes, we've said that in the introductory part. The Commissioner recognized this problem. The processing of data comes after revealing, after giving the personal data. In that sense, we wanted to raise awareness of the younger generations and of the older ones. I've mentioned the digital caravans and other events. We won't stop the society, of course. Each man is social being. Of course, you will be giving your personal data, but you have to assess to what extent we do it. Is it aligned with what we wish to obtain? And now I'm talking from the point of view of an individual. Everyone must be aware of their personal data once the data are shared in the digital space. These data are very, very hardly controlled by the individual and by the Commissioner. We do not know where this data end up finally. And these individuals are actually having a hard time erasing the data. And this is why we try to do our best. But if you want to obtain something, what kind of data do you need to share? Why? Who will be processing these data afterwards? So is this really the currency that you wish to share with others? If you do not know how your data will finally, eventually be processed. The Commissioner and the courts have limited capacities, and we cannot act upon each complaint. We do not have, I repeat, sufficient capacities. This is why we need to have a part of the strategy devoted to reinforcing capacity of courts, of Commissioner and of other authorities. Through the strategy, we also mentioned at the Ministry of Education that syllabus programs for education, they all need to comprise the parts that concern personal data protection. There are just a few lessons in the second grade, I think, but the general population needs to raise awareness of this problem. The society needs to recognize these areas. The society needs to know what can and what cannot be done. Thank you very much, Bogdan. What are the measures that can be undertaken in these areas? You can, of course, mention the digital print if you want to, the enhancement of digital literacy. Yes, you've said that really well. I would just like to continue on the Duško's tone. The society is the starting point. We first need to understand all the negative phenomena, the consequences. We need to understand what the victim will feel afterwards. We cannot only think about mechanisms and their functioning. I've recently read the European Commission report on hate speech. Social networks eliminated 70% of contents that call for murders or that talk about hate speech, but they did not eliminate 30%, and that means that these are thousands and thousands and thousands of hate speech posts. Could the Commissioner react to these thousands and thousands of hypothetical complaints? No. This is why digital literacy is important, especially digital literacy of vulnerable groups. Eurostat's data says that only 45% of people have basic digital skills, which means just sending files, receiving emails. Although a large percentage of population uses the mobile phones, not having sufficient knowledge about the dangers and about everything that can be done with a mobile phone. We need to work continuously in order to increase the visibility of our institution. But other institutions should do the same. For instance, the Office for Organized Crime, etc., etc., in order to make the situation bearable.
Because with zero tolerance will not help us avoid to have zero hate incidents or hate speech. Now it's time for questions of the audience. I'm not seeing because of the light, but we're ready for questions, so raise your hand, please. Thank you very much for your panel discussion. Just introduce yourselves. Marija Zarić, I'm into event design and also in street art. But imagine myself street art and surveillance, for example. This cannot go together. And I'm really about addressing the question of surveillance, and I want to, well, stick something, plaster something on the wall to be seen by a camera. I think it's a monster over our heads. It doesn't exist, respect for privacy. When you see the media, the government controls all these media, for example, our daily newspapers or portals. How have the awareness through this media? Because everybody reads it. And they say, well, hate speech, but they have picked their side, and for example, everything that you said, if you tell them to them and someone can read it, children, they say, well, this is it. Let's raise the awareness through the media. But how? Because we are really living in a dictatorial society, whether we like it or not. We do not have independent media that write about this. The first news should be this. And now everybody thinks about this crime. And they say internet is to blame. No, it's not the internet. It's people's awareness. How should we change this awareness? Some steps in the next 3 months. Surveillance and autocracy, it's an important question. Thank you for your comment and question. We have two different levels of inclusion of the media, of participation of the media, in my experience. We have tabloid media, and which have followed the topic of data protection. We have a weekly conference, every year, Privacy Week, sorry. But on the same website of the same media, we have a story about how to protect privacy. And then you have the reporting about daily developments, which are based on violating, proper behavior and dignity. It's done because it's affordable. And so one thing is, how do you come to this data? What are the sources? These are complex topics, and it's important to have education with the citizens, to speak with them what they share in the media, etc., some personal incidents, and then they share them. But the second thing, and I don't want to be someone promoting repression, but I think that this area, it is important for the media that are violating, well, first of all, the law on electronic media. They should be punished, or meaning fined. We have a developed practice in terms of damages that are quite low. They wouldn't be low but these are media that are funded from public resources. And what should be a systemic solution? Those that violate regulations should not have access to public funds. For example, we have been investigating the Informer daily, and in the last 7 years, this paper paid 27 million dinas of damages due to breaches of violations of rights in their reporting. But in 1 year, in 2021 and 22, they received about 18 million dinas through different competitions. Out of these, 70 million from the cities of Belgrade. Of course, we source this data about damages from the court. So it's a model that, is cost-effective. Of course, there will be no campaigns that will change our practice. They will follow our campaigns, and it will be covered by the essence of media. Reporting is based on breach of rights. All countries have a problem with that. This is content. Well, everybody likes blood, but someone is paying for it, which is not happening. Leaking information to the media. Yes, I can add to the law on personal data protection knows for an exception in reporting, not a total exception, but for the purpose of public information. What does it mean? That the media can process the data that are for the purpose of public information, not outside of it, and they're not exempted. So the commissioner has cases related to the media, and we treat the media as other handlers of the data. The media outlet cannot process just about anything, and simply this is the situation of society, globally also, as Anna mentioned. This is the thirst for such content lately. Of course, we need time to rectify this.
When it comes to the Commissioner for Protection of Equality, we've used all the mechanisms that we have at our disposal. There were a lot of remonstrance, of warning, of recommendation, of acting upon individual complaints. But we also organize trainings every year. We give the media award, and this is how we try to influence the elimination from the discrimination from the media. But it is something that can hardly be defined just shortly in this wrap-up part of the panel. Are there any other comments or questions? We have 4 more minutes. Good day, Thomas Toskić. I have 2 questions that are rather technical ones, but they regard the law. The first one is, does the law recognize technical difference between surveillance and following? Because at the same time, the same device can do both things. And the second one is that you were mainly focused on the use and protection of personal data when these data arrive into the digital world. But there is one little piece of the puzzle that you haven't mentioned, and this is the creation of these data. Is there a competent body that deals with the device gathering the information and verifying if the device is harmonized with the law on personal data protection. Who might reply? Duško? Yes, I'm writing at the same time because I don't want to forget the question, but yes. The competent organ, if we talk about your second question, does not exist. There are some acts that need to be done if we do not process the data, but if we talk about different application and device and assessments of the influence is done, and the opinion of the commissioner is subsequently issued. This is what the commissioner can do from the technical point of view. The commissioner does not conduct an analysis unless in hypothesis ex officio the commissioner initiates a procedure to assess a device that might cause commotion in the broader public. If the device were, let's say, unlawful or illegal, the commissioner could hypothetically recognize that and say that the processing might jeopardize or put at risk the person whose personal data are processed. If I understood correctly your second question. Thank you. I don't think we have any more time. We have 15 seconds, perhaps. Yes, for questions, I'd like to hear the answer to the first question. So if the law recognizes a difference, I can only talk about the law on personal data protection. So all the activities you've mentioned represent data processing. Therefore, the commissioner can actually act upon complaints should this be the case. But you do know that keeping the data without active processing is actually processing. The very keeping of data can be the object of commissioners acting. Yes, that's it. You've answered the question. We might put a parallel with the law on electronic data, and if the surveillance monitoring and following is continuous, we might do something, but the law does not make any difference between the two. Thank you very much. That was it. Thank you very much. I would like to thank all the panelists. And before inviting you to a nice coffee break, I would like to say that we've opened a number of questions and issues. At 1 o'clock, we will have a workshop on human rights when you get out at the left. So despite of the fact that we know a lot about all this topic, there's still room for improvement and for knowing something more. The coffee break will last 30 minutes, and then we will be talking about artificial intelligence. See you soon.